Hi, I'm Carter Clues, your host for the inaugural edition of Inside Judicial Watch. As the name implies, this is a program that takes you behind the scenes of Judicial Watch so you can see what's done to bring about the cases that we argue, what's done to bring about the victories that we're able to achieve thanks to your help and your support. And I'm very pleased today in this inaugural edition to have as our first guest one of Judicial Watch's top attorneys. Ramona Coca has been with Judicial Watch for 4 years, has argued some of the most important cases that we have fought and had tremendous achievements in. And Ramona, thank you very much for joining us.
Thank you, Carter. Thanks for that incredible introduction.
Well, it has the added advantage of being true, as Henry Kissinger once said. And I think that the reason that I asked Ramona to join us in this inaugural edition is because several months ago I was working on a news release and I had some questions about it, and it was about the whole Hillary Clinton email scandal, and I couldn't quite get the background on it correct. So I went to Ramona because that's one of the cases that she handled so well. And as I was talking to her, suddenly she unfolded to me where it all originated. And I was surprised, so I figured that this would be something that, as Judicial Watch supporters, you would also find very, very fascinating. So Ramona, can you tell us, where did the entire Hillary Clinton email scandal begin?
In one sentence, it all began with the administration's false narrative about Benghazi and what caused and what spurred the attacks in Benghazi on the U.S. consulate. So the attacks happened in 2012 in September. Judicial Watch, prior to my starting at Judicial Watch, submitted a FOIA request for talking points that were provided to then U.S. Ambassador to the UN, Susan Rice, when she appeared on the Sunday talk shows to talk about the attacks, what had happened, and what the administration was going to do about it. Now, most of our viewers know, and we all know, there was a false narrative that the administration pushed out at that time, and that was all to blame a YouTube video, that it was spontaneous protests,
right,
not that it was a planned terrorist attack.
Right.
So Judicial Watch had submitted that request in October.
If I may interrupt, let me, if I'm not mistaken now, just remind our viewers that they knew when they put out their phony, spontaneous protest over an offensive video, they knew it was a false narrative because they had been told that it was an organized terrorist attack at that point, correct?
That's exactly right. And that's the reason that the FOIA request was submitted, to find out what the administration knew at the time when this false narrative was being provided to the public. And I started in May, so one of my first cases that I filed on behalf of Judicial Watch was against the State Department, requesting all records that dealt with talking points that were provided to Susan Rice to appear on the Sunday talk shows. In addition, we had other FOIA requests and lawsuits as well, where we were getting the records about the day-to-day, as it was happening, intel from people on the ground as the attacks were happening. And that's how we know that the administration knew it was an attack when it happened. And certainly by Sunday, when Ambassador Susan Rice appeared on the talk shows.
Exactly. As a matter of fact, if I'm not mistaken, the State Department was told by the investigative unit there that this was well organized, and the terrorists knew that they were targeting the ambassador. And then Ben Rhodes, Obama's top communications man, obviously who had conferred with Obama, organized all the PR flacks throughout the government to back up Susan Rice's talking points that, as she put it, it was a spontaneous attack about an offensive video.
Right. Right, and that is the case that blew all of this open. So in that case, we filed the request in October, we filed the lawsuit in June of 2013 because the government was now responding to our request. And that's the case, the seminal case, where we got the email record where Ben Rhodes is communicating with State Department, highlighting the points that should be highlighted for Susan Rice's appearance, including that it was not a policy failure by the administration.
Oh, yes, right, right.
And that they should highlight that, you know, all the protests, because of course we had the spring era protests happening in the region.
And one of my favorite lines from Ben Rhodes' phony memo was that, make sure to say that President Obama was, quote, steady and statesmanlike.
Right. Right. So that is because, now I don't know if you recall, Carter, but at that time we were calling for special investigation into what really happened in Benghazi.
Yes.
And only once the Ben Rhodes, what is now known as the Ben Rhodes email, at that point is when Congress decided, let's go ahead and create a select committee to start investigating the Benghazi attacks. So it all started with that case.
With that case, and
yes.
It was only after you had gotten the Ben Rhodes memo that Boehner was forced his hand, essentially. I mean, the truth is the truth. That's exactly what happened. And how did that then bring about your realization that there was something wrong with the Hillary Clinton emails?
Well, that's a very good question, because Tom Fitton, our president, and I had a conversation when we were receiving the documents in that case, and we got the Ben Rhodes email. We said, where are Hillary's emails in all of this?
Right.
Secretary of State, she must have had to have been involved in this. So our initial request went to one component of the State Department. So to make sure that we did everything that Judicial Watch could do to get Hillary Clinton's emails on the subject, we submitted a new FOIA request specifically to the Secretary of State's office. The Executive Secretariat is what it's called. And for the request was pretty much identical. It just went directly to her office, because none of those emails that we got in the original case included Hillary Clinton on them. So that's what led to the second case that we have, the second Talking Points case.
So you said, where are Hillary's emails? Where are Hillary's emails?
And that's right. That's right. So that case is what is pending currently still in front of Judge Lamberth. And we requested discovery in that case, and we can go into how we got to that point, but just to let the viewers know, that case is currently still pending. Judge Lamberth did say that there was evidence to show that there is a question about the government's good faith in processing the records we requested, and Judge Lamberth did grant us discovery, but we're still, both sides have proposed the discovery that we each think would be appropriate. Of course, the State Department said nothing, that nothing would be appropriate.
Right.
And that's where we are in that particular case.
And when you discovered there were no Hillary emails, then how did you finally force out the, I think, what, 30,000 emails she finally released that she had had on a private server in order to avoid them being on the government server where they belonged?
So this is what's interesting, and this is what doesn't get put in the pleadings and on the public docket in our cases. So we had the same attorneys are involved in the original Talking Points case, same DOJ attorney and myself, and then on the second case. And I told them, look, we're going to dismiss this other case. We're going to settle. We got the records that we needed from the original one that was pending actually in front of Judge Sullivan. And we're going to file a new one because we want Secretary Clinton's emails.
Right.
So he knew exactly that it was the same subject matter, but we had a conversation. Where are Secretary Clinton's emails? So that case, we filed suit as soon as we dismissed the other one in 2014. 2014 now, in December, is when Secretary Clinton returned the records to the State Department. Prior to that, and on the same day in October, the same day that I believe there are correspondence from Cheryl Mills on behalf of Secretary Clinton, is the same day when the State Department responded to us, either October or November, I can't remember the exact date, but I do know that they coincide.
Right.
Was when the State Department told us, we've done a complete search and you have everything that we have. without any, and the only records we got was the emails that were already produced in the other case, but nothing new from Secretary Clinton. And that's when I saw that is when I said, you know, Rob, or the counsel for the State Department at the time, I said, I think we're going to need a declaration explaining the State Department's search, what they did to look for the records we're asking for, where they looked. And
so let me make sure now, the State Department told you we've given you everything.
Yep.
At that point,
that was in November.
But at that point, they knew.
They've been in contact with Cheryl Mills. They've been in contact with David Kendall, with Secretary Clinton's attorneys.
So they knew that Hillary Clinton had all these tens of thousands of emails, and they told you instead, oh, we've given you everything.
They knew they had an entire system of records for her entire tenure at the State Department that they were expecting to come, that Secretary Clinton removed from the government's possession at the time. She took him with her when she left the State Department, and they were expecting him to come back, but they didn't tell us that they were expecting all those records to come back. And what's even more egregious, they didn't tell the court, because this is also in the court's filings at the time. In December is when I get a call from DOJ counsel saying, we're going to have to search a few more emails. Not a word about what emails, what system,
right,
where they came from, why they didn't look at them before, nothing. And then in February, still before the New York Times article came out, submitted another status report saying that they're being searched and that they need a couple more months. But not again at all about the significance of this. This is a whole, it's like a whole file cabinet of all of her emails while she was the Secretary of State.
60,000 of them that she had put on her own email system in her basement, which you then subsequently found out through your discovery. They knew that she had this in her basement, and she had been told that by doing that, she was making it so they couldn't respond to FOIAs. Is that correct?
She had been told that this would bypass the Department of State's record system in response to FOIA.
There we go. Secrecy.
And that came out in the IG's reports, the Inspector General reports that they published subsequent to all of this coming out back in March of 2015.
It's a fascinating story. It's a fascinating story. Talk about hoisted by your own petards, a woman who tried to keep everything secret, and the fact she tried that enabled you to uncover it, and then all of the email scandal, her violations of national security, the Clinton Foundation, State Department, nexus where favors done, money given, all that came out because she tried to cover things up, and you, as Judicial Watch's attorney, uncovered it.
Well, you know, this is the way I look at FOIA. In regular civil litigation, you have discovery, what's called discovery, which is what we did in our other case in front of Judge Sullivan, which is what you're alluding to, the depositions that we took and where we gathered a lot of this information with respect to how it was set up, what was its intent, and that sort of thing. In FOIA, we're limited to one particular request on one particular subject matter. So the way you tackle to find out sort of discovery on a broader scale is you just submit FOIA request after FOIA request on each
Freedom of Information Act.
Yes, sorry, thank you.
Right.
Freedom of Information Act requests. And you just tackle it one by one to get a broader scope and broader view. And just to add, we have a current case in which it's a FOIA about a FOIA, because the case that I was telling you that's pending in front of Judge Lamberth, we want to know what the State Department knew and what the Department of Justice knew when they were informing and when they were submitting the status reports to the court.
Great.
That is part of the discovery we asked in front of Judge Lamberth, but because that is slowly proceeding, we actually said, why don't we just file another lawsuit? So that's also pending right now.
It's fascinating. It's fascinating, and I knew it would be fascinating for our Judicial Watch supporters and viewers. Unfortunately, we are out of time on this inaugural edition, and it has been It's just very informative. It reminds me, I think it was Lord Byron who said, "Oh, the tangled web we weave when first we practice to deceive."
Right.
And what a perfect example of it. Thank you.
Sure
Thank you
thing.
very,
Thank you for
very
having
much.
me.
Thank you for joining us, and we'll see you next week on the next edition of Inside Judicial Watch.